We're going to talk about marital versus non-marital property in a Florida divorce. And when I say marital, I pretty much mean assets or debts that are going to be split during the divorce. And when I say non-marital, we typically mean assets and debts that will remain the property or the responsibility of one spouse in the divorce. There is a default starting situation, and there's a lot of exceptions in the state of Florida. The default starting situation is any asset and any debt that was created before the day you were married. And I mean the day you were married, not the day you were living together. Anything created before the day you were married stays the property or stays the obligation of the person that got that money or built up the debt. Anything after the day of marriage, starting with day one of the marriage, any kind of asset is normally determined to be marital. Any kind of debt is also determined to be marital, and that means the debts and assets will be split between the spouses. There's a lot of exceptions to these starting situations. If you have alimony in your case, that may provide justification for what we call an unequal distribution. That means you get a bigger slice of the pie of either a debt or an asset to accommodate a situation with the other spouse. Also, typically with large assets like real estate, there's a claim for unequal distribution, and that may be because the money used to make a down payment on that property existed before the first day of the marriage. If that is the case, it's very important to trace that money, and it's a very complex claim to make, and you do need expert assistance. We do have an experienced team of attorneys. We deal with this situation day in, day out, and we're looking forward to seeing you for a free consultation. This attorney, Howard Eichen.